Hello, my name is Jacob. I am presenting today for Torts 2 regarding something to do with medical liability and personal injury. The topic I've chosen um, is regarding what liability do the medical providers have, such as, doctors and nurses have, um, against for their patients when administering the COVID-19 vaccines in 2020. So this outline is for the use of patients, the patients themselves, not the doctors and nurses, who have suffered severe adverse effects post the their COVID-19 vaccination, whether the practice, whether the providers use their best practice with the best experience they had, and also whether this discussion, whether the providers had a duty of care to those who have suffered those severe adverse effects, and even in some cases there have been death. So I believe this is an important topic for those patients and for people in the future who will need to be or who are getting vaccinated in the next few months. I think this will be very helpful, and yeah, I'll just discuss any of the reforms that I have suggested, or that I will suggest later on in the video. So just to give you a bit of background, so yeah, over the course of the COVID-19 pandemic, specifically in 2021, there have been a significant increase in the number of COVID-19 vaccinations since its approval by the Australian government. At this stage, there are two currently approved COVID-19 vaccines, and those are the Pfizer vaccine and the AstraZeneca vaccine. While it is proven without a doubt that it has, the results can prevent severe symptoms of the COVID-19 vaccine, of the COVID-19 symptoms, there have been a worrying number of cases where patients have developed, conditions, more specifically with the AstraZeneca vaccine, of a case of like a blood clotting condition, which is called sinus venous thrombosis, so a blood clotting syndrome, and this can happen up to 2 weeks after the initial injection. At this stage, according to the Therapeutic Goods Administration, there have been 125 cases so far of side effects of this severity. There have been others that, headache, but that's normal. I'm more about the severe part. So there have been in Australia 125 of those, and of the 125, 8 people have sadly passed away following this thrombosis condition. So according to the TGA again, it makes the probability of dying from a COVID-19 vaccination at less than 1 in a million. So while that may not sound great or significant compared to other infectious diseases, it still begs the question of whether or not doctors and nurses and other providers have a duty of care to follow up on those patients, post-vaccination, to avoid death, ultimately death. So the current state of liability is set out mostly in common law, which I'll get to in a moment. However, if we go to the Civil Liabilities Act, Section 2 more specifically, it basically says, well, it states that any act taken place is subject under this act after the commencement date, which is the 2nd of September 2002. And also a range of provisions allow for the duty of care to be applicable, such as in Section 4 of the Act, which are done after the date of assent. And in Section 22 provides where the proactive and reactive duty of doctor to warn the risk before medical treatment or to take reasonable steps and fails to inform a patient about that risk. So the statute allows us to use duty of care as part of medical liability and personal injury, redeemable compensation. So now I've got to break down the different types of duty of care that I have identified. So we'll first go back to the foundational cases for duty of care. So in Heaven and Pender, that case pretty much sets out that in a situation where the plaintiff invited the defendant to a premises to do a thing or to do an act that they were prescribed to do, then the defendant or the occupier of the premises owes a duty of care to the to all invitees, and so that's any reasonable care. This, of course, does not extend to people who have not been invited to the premises but were there anyway. So there are cases for that. So in the case of our patients, it could be argued that they, through their vaccination appointments that they make by the clinics, that they are invited to go to their premises, and they have a duty of care that while they're on their premises or had done a job on the premises, that they would have a duty of care to continually protect their well-being. And so I think it should be extended upon by them. The next element we need to identify is whether it was reasonably foreseeable the COVID-19 vaccinations would cause serious adverse effects to patients. Section 12 of the Civil Liabilities Act provides that the onus of proof is on the patients to show evidence of the breach of duty. So that means the patients need to prove their personal injury, which is achievable. However, determining foreseeability will include looking at the salient features, such as the nature of the harm, whether there was an element of control, vulnerability, or knowledge the defendant had relied upon by the plaintiff. So while this may seem easy to prove in theory. In reality, due to a lot of hard novel cases, the aspect of foreseeability has not, or is more of a defendant, it's just more defendant friendly. So yeah, for example, in the case of Sydney Water Corporation and Toronto, the majority held that foreseeability could not be taken too broadly, and that only specific circumstances may be considered a breach of duty. Further issues arise if it is determined the scope of foreseeability is still minimized by cases to reduce, well, the reason for this is to reduce the floodgates from opening up. There have also been hard cases where, so in the CAL number and motor accidents insurances case, it is required for there not to be only vulnerability, but also the absence of autonomy. So the freedom to make one's choices. So I guess the defendants or the providers could argue that this could be personal. It could be a personal responsibility issue. That the extent, the scope of the duty of care was too great for people. So with that being said, we have a few recommendations to present. So I have recommended that we put in place a no-fault system in place by amending, so fully put it in our Civil Liability Act to include it as it is, just to guarantee compensation for patients who specifically suffered severe adverse effects from COVID-19 vaccinations. While there is already a government-funded no-fault system for COVID-19, it would be better if it was incorporated in the Act to avoid confusion to the reason for compensation. It is also recommended that the bulk of compensation is funded by pharmaceutical companies, as seen in New Zealand and Japan and France. The efficiency of processing claims in 2019, for instance, 1,590 claims were processed in Japan, and all totaling $22.6 million $22.6 million was paid within the fiscal year. So in conclusion, it is important that we implement these these cases for the purpose of better compensating our our people, so that as time goes on with the pandemic, it's clearly not getting better anytime soon. Earlier in late September, there will be an introduction of a new Moderna vaccine, as well as the Novavax in January 2022. So there are likely to be far more adverse side effects that will need to be addressed legally as well. So I hope this helps, and thank you for listening.